Morning, everyone. We're about to start in a few minutes. I'd like to ask everyone to just silence their phones or silence. Thank you.
Thank you, folks. Have a seat. And good morning. So we're here for oral argument in 1 CATX, tax case 24-0003, Arizona Cardinals versus the Arizona Department of Revenue. These proceedings are being video and audio recorded, and I was going to ask you to do that, and that was my way of teaching you to do that. I don't even know how it is that this is still on, so I'm going to take a moment. And for the students in the room, you see now judges are not perfect beings either. And for some reason, it's not letting me do this. I did not. All right. So don't do that. All right. So the proceedings are being video and audio recorded, and they're being live streamed at the same time. So with that, we ask counsel, as you approach the podium, to please state your name and identify the party you represent, so the folks watching remotely and the folks in the audience know who you represent. Each side does have 20 minutes. You are welcome to use that as you deem fit. You're not required to use it all. You're responsible for keeping track of your own time. So counsel, if you wish to reserve any time for rebuttal, you're welcome to tell us, but we're not going to guard it for you. And we will then let you use that. Keep in mind, we have read the briefs, I promise you. We've studied the case quite a bit. We've conferenced it earlier this morning. And so we are very familiar with it. So please, I would suggest you not simply repeat what's in the briefs, but tell us what you think is critically important as we go through this. And with that, counsel, you may begin.
Good morning. I'm Frank Crociato with Spencer Fain, representing the Arizona Cardinals Football Club, LLC. I have with me co-counsel Kevin O'Malley with Gallagher and Kennedy. May it please the court, I would like to reserve 4 minutes of my time for rebuttal, please. The main issue in this case is whether facility use fees, or FUFs, that the Arizona Sports and Tourism Authority imposes on ticket purchasers and then uses to repay its bond debt constitute gross income to the Cardinals? The answer is no, because the Cardinals collect those funds as agent of ASTA. Arizona case law, such as Abasco Services, has held that when a taxpayer receives funds as an agent, those funds are not subject to TPT. Here, and this is critical, the contracts plainly state that the team collects FUFs on ASTA's behalf, that the team has no right, interest, or any ownership of the collected FUFs, and that its primary function is to remit those FUFs as directed so that ASTA can pay its obligations.
Mr. Crociato, doesn't the use agreement, the fee agreement, and the trust agreement each explicitly state that the Cardinals are not an agent for the authority?
There is an agency disclaimer in the general terms and provisions, but agency is viewed, according to this court and Southeast Arizona Medical Center, on the totality of facts and circumstances. And there's a difference between general agency and limited agency. When you look at the operative terms of the FUF agreement, right, agency is a fiduciary relationship requiring one party to act on another's behalf and subject to its control. When you look at the terms, the obligations, the core terms of these agreements, the Cardinals...
Well, let's talk about the core terms. These agreements were created for what reason? What did the authority give up for you to enter into this, for your client to enter into this? Parking. In lieu of a parking and collecting on parking, we're going to do this fee. And who got the parking and all fees associated with it in that deal?
Okay, so there's...
No, who got it? Just answer the question.
Okay. It never occurred, is the answer. That's one of the problems. The parking provision, and so there were obligations of various political subdivisions to establish parking. Those obligations never got met. And so the parking...
But that's not what's before us. I mean, let's talk about the deal. The deal was in lieu of parking, so that's how this was all set up.
That's how it was originally set up, and the team...
There's nothing else in the record before us beyond these documents, right? There's no, oh, this didn't happen.
The settlement agreement was referenced in the brief below at the tax court. But the fine point I want to make on parking is the Cardinals don't get parking revenue. The parking revenue under the original term of the agreement went to New Cardinal Stadium LLC.
Right.
That is a separate entity. It's a separate TPT license number. It's not the taxpayer in this case. And in TPT cases, we don't conflate entities.
It's an affiliate.
It's an affiliate.
An affiliate of the Cardinals got the parking under the agreement.
Correct.
Right.
And that affiliate
the
had
other thing is, if once the bonds are paid off, they get to keep it, right?
If there's money left in the
Yeah.
clearing account after the bonds are paid off, yes.
They get to keep it. So there's more of an interest. That's not just an agent. That's an interest in this.
Well, that's a back-end issue.
It said actually, are the Cardinals just an agent when they hold an interest? Because you say they gave up everything, but they didn't. They still hold an interest.
They don't hold an interest in FUFs collected from ticket purchasers, which is what the department based its assessment on. 25 years from now, if there's a residual in that account, some may come back to the Cardinals. But the transactions being taxed are the FUFs collected from ticket purchasers, and the Cardinals do not hold an interest in those monies.
Where in the definition or in the statute does it say that that's the way this is going to work? And what I'm particularly looking at is in 425073, it says, for purposes of this section, admission or user fees include, but are not limited to, any revenues derived from any form of contractual agreement for rights to or use of premium or special facilities or arrangements. How do these fees not fit within that very broad definition?
Because they're ASTA's fees, not the team's fees. If the Cardinals, for example, contract with an entity to so that entity can use a suite as a Cardinals home game. That's what's intended by that provision, right? It's a special contractual arrangement for the use of premium seats, such as a box. Here, as to the use fee, it's a cognitive ease argument in the sense that when 5073A refers to user fees and contractual agreements, it's not defining the tax base. It's defining the types of fees that can fall into the business activity subject to tax. The tax base is gross income. That's in 5073B, okay? And so just calling it a user fee or a contractual agreement for the right to have premium seating, the Cardinals pay tax on the fees that they charge to ticket purchasers under contract to use suites. They've already collected and paid those taxes. So the issue is, and I think responding to your question, how is that not part of the tax base, is the tax base is gross income. And there's a fundamental disconnect between...
Which includes admission or user fees. Gross income includes admission and user fees.
No, the tax base, the tax classification. If a pool hall charges you a $45 an hour fee to use a pool table as a use fee, right? That pool hall is taxable because it's charging it. The tax base is gross income. And there's a fundamental disconnect between the department and the Cardinals on what gross income means. It's that same fundamental disconnect that was at issue in Abasco in Ormond. And the disconnect is this.
Did Ormond have any residual interest in any of the money that we can see from the case?
That we can see from the case, no.
None of them had a residual interest in it?
No.
Okay.
No.
So the agency sort of falls off there, and you've got an express disclaimer of any agency in your agreements.
So I don't think the agency falls off because what the department is assessing are taxes collected from ticket purchasers. They're not assessing a residual. The Cardinals have no ownership interest in these funds at all.
It's not just money from ticket sales. I mean, that's not the only thing that gets taxed in the TPT, is it?
No, the Cardinals have...
Thank you.
The Cardinals have already paid tax on the full amount that they as a business charge to and earn from customers, the face value ticket price.
And one of the things your client could have done is just included it in the face value of the ticket price.
But
So you're somehow being able to, and if you had done that, would the outcome be different? Or if your client had done that?
there's no reason for the client to have done it. It's not a charge imposed by the Cardinals. It's a separate charge that's imposed directly on ticket purchasers by ASTA. So
There's no requirement, though, that the Cardinals pass that fee along to the ticket buyer. They have to pay it, but there's no requirement that they charge a separate fee when they're selling tickets to the ticket buyer for the facility use fee, correct? They don't have to collect it as a separate line item. They could just roll it into the price of the tickets, couldn't they?
They could,
Okay.
but why would they? It's a charge imposed by ASTA. So the fundamental difference, I think, judges, is
Well,
in
it's
saying...
a charge that the Cardinals and the authority agreed to charge, not just that they did it. This was done in lieu of the parking, and the Cardinals agreed to do this. So this isn't, I mean, they could have charged that and figured out a different way to collect it. You folks agreed to this process where it came into your client's coffers.
Just as Orman did, in a very real sense, that ASTA imposes this fee. It was imposed by resolution. This wasn't a contractual agreement. ASTA resolved to impose this fee to pay its bond debt. Then it entered agreement with the Cardinals to have the Cardinals collect it on its behalf from ticket purchasers. The incidence and the imposition of the FUF is from ASTA directly to the ticket purchaser. So in a very real sense, it makes no sense for the Cardinals to include it in a ticket price when it's not a charge that they make.
Okay.
I do want to cover the agency concepts and some of the case law on that, because the fundamental disconnect, I think, between the Cardinals and the state in this case is the department is viewing what gross income means as the total amount paid by the purchaser. The Cardinals think that the tax base is the total amount that they charge and earn in their own right. And the agency cases inform the difference in interpretation and support the Cardinals' position in this
Let's
case.
just start with the first thing in the Ormond, the agency case, which is the strong evidence and the highly relevant evidence, pertinent if you will, which is the fact is highly relevant that the team is getting the money. Just like in Ormond, it was highly relevant and showed direct financial dealings with the team and the authority. And there's evidence that there was a legal responsibility for the fee. That factor weighs in favor of finding it to be a taxable fee. Then Ormond goes on to some different things. But aren't we different than Ormond? Tell me
No,
why we're exactly on all fours, because I see some big differences.
we are exactly on all fours with Ormond because all the team is doing, right, is acting as a conduit. The fundamental difference with Ormond is the direction the agency flows. In Ormond, they collected the fee from their principal and paid it to third parties.
With whom they had no contractual obligation or involvement, right?
Correct,
But here, just
Well, no.
hear me out. Here, there's a direct contractual relationship between all three of them, the ticket buyer, the team, and the authority, because I sell the ticket, and so I've got a relationship with them, and I got to give them the ticket and collect the fee. And then I have to turn around under the agreement and give that to the authority. The difference with Ormond is there was no obligation, no contractual relationship between what you correctly identified as third parties. This is all tied into one transaction.
No, I disagree, because in
Okay.
Ormond, the construction manager in Ormond was actually supervising and coordinating the work of the trade contractors. It was responsible for scheduling that work, making sure it was completed. It had a person on site to make sure the trade contractors were doing what they were supposed to do. There's two differences in this case that are meaningless between the Cardinal situation and Ormond. One is the directional flow. In agency, it doesn't matter whether you collect funds from a principal and give them to third parties, or whether you collect funds from third parties and give them to a principal. The agent is still, it's as if the principal is acting itself in an agency relationship. The only other difference, which is rare, that occurs in Ormond in the context of agency, is that the trade contractors had entered contracts directly with the school districts, okay? That's very rare in an agency relationship. That didn't occur in a BASCO, right? And so the reason that ticket purchasers are directly liable to ASTA, as the school districts were directly liable to trade contractors, is because ASTA is a political body of the state of Arizona acting through its statutory authority to impose a facility use fee on those ticket purchasers. ASTA's relationship doesn't arise with ticket purchasers by contract, it arises, I guess, by license, but in either event, that's not determinative of an agency, because in most cases, a principal wants an agent to deal with third parties because there is no direct privity with those third parties. Those are the only differences with Ormond.
And it's a big difference, because we've got the relationship of the team in the middle. That's Ormond. Team's in the middle. And the team has to collect the fee or not. It can just sell the tickets. But no matter what, it has to pay the authority, right? So
No.
there's a legal obligation. In fact, if it gives too many tickets away, it has to pay the fee itself. It's not just an agent on that.
It is just an agent, and here's why. First of all, this notion that if it doesn't collect it or doesn't remit it, it's directly liable. Any agent that fails to perform its function as an agent is going to have adverse consequences. No provision in the contract say that, hey, Cardinals, if you fail to collect it or you fail to remit it, you're directly liable. It gives as to the remedies that it would have under law or equity, which includes specific performance. Hey, Cardinals, you didn't collect it from these ticket purchasers? Go get it. That may seem unreasonable or not administrable, but the opposite happened. The ASTA said, hey, in 2023, you guys collected more FUFs than we actually charged. refund them back to the ticket purchaser. So that's part one, the answer to the question. There is no direct obligation, no direct liability of the team. It would be breaching its agreement to act as agent.
On the free tickets, there's absolutely a direct obligation. The fee is not just something that is out there floating in midair.
I understand that point, and here's what I would say. The assessment has nothing to do with complimentary tickets. The assessment is based on funds collected from ticket purchasers. So in one sense...
Unless they give away more than
perfect.
$2,000 or the amount allowed, in which case it is also on those excess tickets.
Correct, but let's look at what's happening there, right? The FUFs are ASTA's primary source of funds to pay its bond debt, okay? And ASTA has imposed the FUFs on the ticket purchaser. ASTA needs a certain amount of funds to repay that bond debt. And so what it says through the complimentary ticket provision is, Cardinals, I mean, this actually supports the Cardinals' position. Cardinals, if you give away more than you're allotted, you can forego your own revenue that you earn as a business. You don't have to collect the face value ticket price, but you can't forego our revenue because we need it to pay our bonds. And what that shows is that in those limited instances where excess tickets are given away, the Cardinals have to step into the shoes of the ticket purchaser so that ASTA has its funds. It doesn't alter the character of the FUF. It just says, in this limited circumstance, we need the money that we estimated, so you've got to pony up if you give more tickets away. The imposition of the FUF is on the ticket purchaser, and the treatment of complimentary tickets doesn't alter that. I see I'm down to 3 minutes. I'd like to reserve the remainder of my time unless there are more questions.
I'm Scott Teasdale, Assistant Attorney General, representing the Arizona Department of Revenue. May it please the court. You'll have to excuse my voice. I've got a bit of a cold this morning. Not COVID or a flu, however. In this case, the Cardinals sell tickets to their customers, and from that gross income, pay some of that revenue onto the venue at which the seats are located. The Cardinals make what to me is an amazing argument, that they can exclude some of the proceeds from ticket sales making up the tax base by virtue of their contractual agreement with ASTA, by which they pay some of that revenue on to ASTA.
Let me ask you a question on that, and we'll get to Ormond, but could the Cardinals enter this kind of agreement with any venue? In other words, let's say you owned a venue, and the Cardinals wanted to use it, and you said, well, there's a user fee, so I want this agreement that you're going to collect this user fee for me. And could a private entity do that?
Yes.
And avoid the TPT?
Not avoid the TPT, but this is the problem, that assignments of one's revenue in advance, generally known as anticipatory assignments, could be entered by any taxpayer in the amusement classification or in many other classifications to pay on some of the revenue they collect from their customers and say, I'm an agent collecting that, or I'm holding this in trust. And the parade of horribles here, when you extend this beyond the amusement classification, is huge. If you look at retailers, consignment shops and auctioneers are taxable on the entire amount they collect from their customers, even though they're paying on generally the lion's share of that money to the owner. They may also have provisions where they're acting as the agent for the owner in making those sales, and that they're paying on these proceeds and that they don't own the owner's share, or that they hold it in trust, which is often used to render those proceeds hopefully bankruptcy remote in case the auctioneer goes bankrupt.
I guess where I was headed, so that if they can avoid paying the fee to service the debt, which is how the stadium got built, then couldn't any other entity, including Cardinals, going to a different stadium and say, look, let's set up this thing and you charge the fee, and that way we don't have to pay for this?
Yes, I believe
And that's
that,
the problem, is this sets up exactly what the legislature said no deductions were allowed from, so that we don't have this avoidance of tax liability by the offset of different expenses or contracting away these expenses.
yes, in any amusement venue where the venue is not owned by the operator could easily enter a contract with the venue owner saying, you, the venue, are going to charge a fee to the customer, we're just collecting that for you as an agent. That could happen in a movie theater or in many other amusements.
All of them could really go to this model and then avoid the TPT on everything
Yes,
related to that fee.
unless there's some way to distinguish it as being a governmental entity, in which case it would only apply to governmental entities. But in
Which I
terms of
haven't
the
heard.
legal principle, we don't see how you would be able to limit it that way if it's based on simply a contractual agency.
Well, wasn't this adopted by a resolution? The fee imposed by a resolution, as council said?
Well, when you say it's adopted, I guess you have to look at what a resolution is, and the case we found, the Alpha LLC v. Darrett case, stated the term resolution, generally speaking, is simply an expression of the opinion or mind of the official body concerning some particular item of business or matter of administration within its official cognizance. A resolution is not a law or an ordinance, but merely the form in which a legislative body expresses a determination or directs an action. So I suppose the question there is, can a resolution exclude proceeds that are within the statutory tax base? Saying, don't worry, we're a public entity, so you, the taxpayer, that portion you're collecting and paying to us is now exempt. We don't think that ASTA has that authority.
Do you have some case law to support that?
Certainly, the Van Gilder case involving the Pinal County transportation tax, in which the Supreme Court said that a tax put to the voters, passed by the voters, which attempted to exempt part of the tax base for single items over $10,000 from the tax base. The Supreme Court said, no, you cannot do that because the statute controls what the tax base is, and all you can do is adopt a rate. You can't generate a new exemption at the political subdivision level that is not statutorily authorized.
Let's talk about the timing of which the Cardinals, the team holds the funds. It's apparently in a trust account after the tickets are sold, and they're held in a trust account for a certain number of days. Is that?
No.
No.
The
Correct.
contract says both that they're acting as not acting as an agent, but it says they're holding it in trust. But the testimony in the depositions from both the Cardinals and from ASTA is that the money, when you buy a ticket for cash, it goes in a common till. That's then deposited in the Cardinals bank account. If it's paid with plastic, that money also goes to that same Cardinals bank account. And then after each game for which a ticket is sold, the Cardinals then remit that money to the ASTA account. So if you have a season ticket after each game,
Is this in the record? Yes?
yes, that is in.
'Cause I didn't catch that from the briefing.
Perhaps I left that out, and but that is
But
that is on the record below, Your Honor.
Regardless, let me give my hypo, and I'm sure you'll come up with a good way to knock it down, but let me try. So if the money exchange, if the ticket, I swipe my credit card goes through, I buy a ticket, the $6, whatever it is, the $6, what if it is automatically, at that point in time, within seconds, it's deposited into the authority's bank account? Does that change the department's position on whether this falls into the TPT?
No, Your Honor, and in that case, I'd refer you to this court's decision in the Home Depot matter that I argued many years ago, and that concerned the Home Depot attempting to claim a bad debt deduction on a theory that the fees that it paid to the credit card issuer out of the purchase price, where it never received the money, and some of those amounts could be upwards of 15% of the purchase price on which Home Depot paid taxes, were retained by the credit card company to cover its expenses, and that's essentially an expense Home Depot was paying, and yet the tax base is the amount that they sell for, not what they get to keep. And Home Depot, Home Depot said, Taxpayer is allowed to lower the tax base only with cash discounts. Now, with fees, it pays to its vendors as part of doing business.
So a question, because you mentioned about the money going into the general account until the game is played, which is how I understood it would occur. And only then did it transfer to the trust account, right?
It then transferred to ASTA's account, yes.
ASTA's account. Now, how did they calculate interest on that? Because that's, when it's in this combined account, how is the interest being paid? Who's keeping it?
We didn't explore that, Your Honor, so I don't know.
Because I know there's some discussion about the interest going to the authority, but it seems while it's in this joint account that may not be happening. And I'm not quite sure, and if it's not in the record, that's fine, it was just a question that came up.
It's either not in the record or it's not in my memory of the record, Your Honor.
Okay.
Mr. Teasdale, the authority is a governmental entity, correct?
Correct.
Can you give me an example, another circumstance where a private party is required by law to collect a fee, to remit that fee to a governmental entity, but also has to pay TPT on that fee? Is there another circumstance that you can think of where that occurs?
Yes, governments impose many fees and costs on businesses that they pay out of their taxable revenue that's taxable under the transaction privilege tax. For example, if you hire a contractor and they're required to pay building permit fees or application fees to get their permits, that's going to be part of their taxable revenue. There are probably many others, but I haven't tried to create an exhaustive list. But I don't really view this as being a tax because we do have authority in the Sabin case that says that ASTA can't impose a tax. It can only charge for the use of its property. So I don't think we can treat this as though it is a sales tax like they have in other jurisdictions.
Correct me if I'm wrong, the resolution doesn't make the team do it, it's the agreements the team voluntarily entered into that caused the team to have to collect this for the authority.
That's correct.
So
there's no way
There's
that
a
could...
difference between the team, or the authority couldn't force the team to do it, the team had to agree to do it, correct?
That's correct, Your Honor.
And they did get the parking under this. And I understand there may be something, but there was a bargain for exchange for this fee.
It's a little fuzzy how this all developed, Your Honor. We had only two witnesses we deposed, one from ASTA and one from the team. Neither was around when this was negotiated, and neither knew anything about the parking.
The express terms of the agreement say in lieu of collecting parking. So I think we do have
That's what I asked
some very
about.
valid authority on that point.
That's what the contracts say, and that's what I would go with, Your Honor, that it was related to an agreement regarding the parking. There's a lot said about agency, and again, I think my basic argument that...
Tell me why Orman doesn't apply. That's where I was just going to go. I'm sorry to want to keep you in the right direction.
Orman merely allowed a prime contractor to pay subcontractors to whom Orman was not indebted on behalf of the owner. Orman did not have contracts with the owner, and therefore was simply acting as a payment agent as to those sums. Contracting gets complicated. The law is that there is no obligation that a contractor supply the materials used on the project. If I want to have my house painted, I can go buy the paint and have the painter apply it, and the costs of that paint are not going to be part of the revenue it receives that it is taxed on. If I have an account at Sherwin-Williams, and I say, go down and pick up the paint on my account, that will be a sale Sherwin-Williams is making at retail, since I am not reselling that, and the TPT is therefore paid at the retail level. If I tell them to buy at retail at Sherwin-Williams on my account as a purchasing agent for me, then that contractor can also not be taxed on that revenue, because again, it's going to be taxed at the retail level. But if the contractor buys the materials tax-free under a sale for resale exemption, so the retailer is not paying, then that gets, then that payments to them become part of the contracting tax base. But contracting, again, has a lot of moving parts, with a lot of parties going on. But I think the key quote in Ormond is, conversely, a prime contractor who is legally responsible for paying subcontractors cannot escape tax by having the owner of the project pay the subcontractors directly without the funds going through the prime contractor's hands.
Which is what we have by contract happening here.
Yes, in my view, that is what we have going on. I would also point out that with Ormond, you can have multiple prime contractors. People think of a prime as being a general, but basically the prime is the person who contracts with, the contractor who contracts with the owner. So a plumber who directly contracts with the owner could be a prime, the framing contractor could be a prime. So then you might have a manager who's not contracted with these people, who's acting as a payment agent, but each of those prime contractors is going to be liable for the contracting tax. So there's no base erosion in this. It's simply deciding, okay, where is this being taxed? Is it being taxed by this contractor or that contractor at the retailer? And again, these contracting cases, because of the nature of contracting, can get complicated. But the basic principles we get back to, and yes, I guess the other quote from Ormond is, the key point is that Ormond was not liable to the trade contractors for the payments.
A key difference is also, from my, and I'm asking, is that there was no way Ormond, the contractor, could keep this money. But in the contracts here, there are ways that this money makes its way back to the team.
But potentially, at the end of it, the residual would be retained by the team. We did not focus on that because just about every transaction privileged taxpayer has a lot of money flow through their hands to those who are upstream from them. And it is extremely rare, unless there's a statutory exemption, for those proceeds not to be taxable. It's important to remember that the transaction privilege tax is not like a corporate income tax, which is a tax on the net after you deduct your business expenses. It is a tax on the gross. And of course, we have some argument about gross income or gross revenue, and whether that gross revenue definition feeds in, or whether we just stay with gross income. But the key here is gross. That is the key defining characteristic of the transaction privilege tax, and that's its beauty and its simplicity, is we do not have to go through what is immediately expensable, what has to be depreciated over time, all those complicated factors. And
Let me ask
So
you
do we
this.
need, do we need to decide precisely whether gross receipts are at play here, given whether they're retail, because help me understand that a little bit better, but if it's, do we need to go there?
I view it as a distinction without a difference. So no, I don't think you need to go there regardless. And I would say, as I put in the brief, they cited the gross receipts definition at tax court. Now they say the tax court erred in using the gross receipts definition. And I say, okay, fine, let's back it out and just look at conventional definitions of gross income, which also don't allow for deductions for business expense. And I think we end up at exactly the same place.
And tied into that, because under 5073, there are a list of things that I'll start with under A that are not, trying to get to the magic words here, that the amusement classification doesn't include, and I don't, as I understand it, there's no argument that this fee falls within any of those. The activities or projects of a bona fide religious or educational institution, things like that. Nobody's argued that any of those exemptions, those do not include, are
No.
involved here.
No
And then we go to
statute.
B. And B says, and that's where I'm headed, so give me a moment. B says, and I'll get there, I'm just moved too quickly, the tax base for amusement classification, so the base, is the gross proceeds of sales derived from the business, and then lists exceptions that are not included, and no one's argued that any of those exceptions.
That's correct. There
So
are
the only way
no
you get there-
statutory deductions or exemptions at issue. The only way you get there is you decide that a portion of ticket sales revenue is not part of the tax base, essentially because it's paid on to the venue. Again,
And the
we think-
legislature could have easily included something like that in one of these.
the legislature is not shy about creating deductions. If you look at the retail classification,
We've
it's,
got a lot.
yeah, we've got a whole lot. And if this is a particular problem, and if the legislature wishes to act to say that the amounts collected in this manner are not taxable to the amusement business, if they're paid to the stadium district and used to pay off bond indebtedness, that's entirely a legislative decision. And the advantage there is it doesn't imperil the tax base generally, because they can narrowly tailor it without trying to shoehorn this into the idea that agency creates self-generated exemptions. I think going way back to Quebedo Chevrolet, that is a key case. This is in the early days of the transaction privilege tax, and the issue was the tax itself part of the tax base on which tax had to be paid? And the answer there was yes. Now that's been changed by statute now. Now there's a deduction for amounts collected for transaction privilege tax. But what it said is the terms gross proceeds of sale or gross income from the business upon which the tax is based includes any and all sums received, regardless of whether or not the retailer separately bills to his customers the privilege tax he is passing on to them, and whether or not he segregates the amounts thus received. This is just the basic tax law of a privilege tax, that there are no deductions. It is a tax on the gross.
And that's what they said in the statute itself, is we are doing this to keep it clean, as it were.
If you look at the levying statute, ARS 42, 5008, it clearly implies that it is a tax, or states it's a tax on the gross. It then refers to, you look at the amusement classification, and it seems to entirely cover this. And then when you look at the definitions of gross income, gross revenue, or just gross income as defined in common definitions, we think this would entirely be covered.
One question, and I'm going to indulge in, as the presiding, and ask one follow-up, and I'll give you an extra minute on your time. In terms of ambiguity or non-ambiguous, is it the state's position this is a non-ambiguous statute and that we don't need to get into the liberally construing it in favor of the taxpayer when we have an ambiguous statute?
We do not think it's ambiguous, and we view that while they're characterizing this as a tax base issue, is this taxable ab initio, and claiming that therefore the burden is on us. We view this as being within ARS 425023, which presumes that all revenue from the business is taxable until the taxpayer establishes otherwise, and that they're seeking a deduction from the tax base on which they have the burden, and deductions are narrowly interpreted against the taxpayer.
All right. And so what I'm going to do is give council a minute and a half. Thank you.
Thank you.
I'm assuming there was nothing further. Sorry. So let us reset the clock here a little bit. So it should be 4:21. We're going to get there, council.
Okay.
And maybe you can address the ambiguity issue first, whether
Yeah.
we're really trying to construe something liberally or not.
Yes. You can look at Capital Castings, Supreme Court case, and it will set forth the rules of statutory construction, and this is uniform across all states. When you're looking at tax imposition, the statutes have to be construed strictly against the state with any ambiguity resolved in favor of the taxpayer.
But if it's not ambiguous, we don't get into that.
But if it's not ambiguous, you don't get into that. I think by virtue of the Ormond case and the Abasco case and the Indigo case and the Gillette case, there's an obvious tension between whether that meaning, gross income, means all money paid, regardless of whether the taxpayer actually charges it and earns it, or whether it means did the taxpayer actually earn it. In ADVO, this court said the first inquiry in determining whether something falls in the tax base is, did the taxpayer actually earn it? And that's apparent that the Cardinals don't in this case. It's a charge that's imposed completely by ASTA to fulfill ASTA's government functions. Now, I do want to point out, Judge Goss, yes, so we are dealing with that predicate question. That's the only question we're addressing in this case. Is it gross income? And when you're interpreting that statute, the statute is construed strictly against the state, and any ambiguity is resolved in favor of the taxpayer. When you look at the presumption that the department referenced in 5023, right, that reads, it is presumed that all gross income of a person from taxable activities, right, is presumed taxable until contrary is proven. Well, to get it into the presumption, it has to be gross income. And we're asking that first question, is it gross income? So I think the department has flip-flopped to try and get narrow construction by claiming, we're claiming some sort of deduction. We're dealing with the predicate question. I also want to point out, there is no case cited, and Judge Beck, this goes to your question. There is no case cited in any of the briefings, or that we are aware of, whether it's an anticipatory assignment case or the Cubido Chevrolet type case, that upholds the imposition of a tax on a fee or a charge that the taxpayer in its own right does not impose on its customer and does not earn in any conventional sense. There is no case in the record or that we are aware of that does that. All right, so the fiction here, as it was in Abasco, right, goes to your point, Judge Goss, this FUF is not contractually created. The FUF is imposed by ASTA as a duly imposed fee by a political body of the state of Arizona. ASTA has 3 people working for it. It can't collect it. So it enters an agency agreement with the Cardinals so that the Cardinals collect it on its behalf to meet its obligations.
An agency agreement that explicitly says the Cardinals are not an agent.
Again, it contains a general agency disclaimer, but the totality of the facts and circumstances where I was going earlier is, when you look at these provisions, okay, the FUF in the resolution and the contract, it's express. The FUF shall be collected on behalf of, for the benefit of, and in trust for ASTA. When you look at 3.6.1 of the FUF agreement, it says at no time shall the Cardinals have any legal, equitable, beneficial right to the FUFs or even possess them. When you look at the basic obligation, right, the Cardinals' sole function is to remit FUFs to ASTA's designees so that it can take care of its obligations. And when you look at elements of control, right, the law of agency comes with a requisite right of control. That pertains to the matters entrusted to the agent. And when you look at that, ASTA controls every aspect of FUF remittance, collection, and handling.
It didn't do this out of the goodness of its heart. It did this, it agreed to this in lieu of the parking that the ASFA or the authority could have taken and didn't, and gave it to the team's affiliate. So this isn't being done out of some generosity. The team's getting some benefit out of this, right?
Not that I see. I mean, it's not, the team isn't responsible for parking. The team doesn't earn parking revenues, right? The team actually,
Under the agreement, the teams, and as they were laid out, under the agreement, the team's affiliate got the parking.
Correct, and the parking provisions never came to pass.
And the team, again, gets money, or the team's affiliate at least, gets money if there's any left over.
In 30 years, yes. But again, that's not what the tax was imposed on. And I think it's also important to understand.
Well, it's not a tax, it's a fee.
That's not what the department is assessing on,
Right.
is the way I should put it. I think the final point is look, this is so straightforward in modern times, right? When this was developed, they were paper tickets, right? In modern times, ASTA could put a machine at the gate, right? Have someone swipe a card and have it go directly to ASTA. The point being, if the FUF didn't exist at all, or if ASTA collected it itself, what the team charges for a ticket and what it earns from selling a ticket would be exactly the same, because it doesn't earn the FUF. Thank you.
All right, thank you, folks. We appreciate the argument. We will take the matter under advisement and issue our decision in due course. We're going to stand adjourned so that they can set up for the next oral argument.
Frank, good job. I won't shake your hands again, but,
Fist pump.
There we go.